Hello from Mexico City and welcome to Crossing Borders with Nathan Lustig, where I have conversations with entrepreneurs doing business across borders and the people who support them, with a focus on those with some connection to Latin America. This episode is brought to you by LatAmList.com. If you like this podcast, you'll enjoy LatAm List's daily tech news. If you like the podcast and want to go deeper, check out Crossing Borders, a venture capitalist guide to doing business in Latin America. I took my experience living and working LatAm for the past 8 years and paired it with excerpts from Crossing Borders conversations with more than 30 entrepreneurs. You can buy it on Amazon today. My guest today is Sofia Yagüe, a Spanish attorney at Next Legal, a Miami-based law firm that specializes in Latin America, U.S. business deals with a focus on entrepreneurship and venture capital. This episode is a little different from a normal episode. We quickly cover Sofia's background and then jump into frequent legal mistakes that Latin American entrepreneurs make, the best structures for raising venture capital in the US or abroad, along with tips and tricks to make sure your startup doesn't have problems down the road. We go pretty deep into some of the legal topics that probably only entrepreneurs and investors will care about. So if you prefer to hear entrepreneur stories, maybe listen to the first part of it to learn about Sofia, and then maybe skip the rest. I'd love feedback on whether you like more episodes like this in the future where we go deep into a topic that maybe is more in the weeds that only entrepreneurs are going to be really interested in. Although Sofia is an expert, none of what we talk about should be used as legal advice. Talk to an attorney or an accountant before implementing anything that we talk about on here. Hope you enjoy this podcast with Sofia Yagüe. Hey, Sofia, welcome to the podcast. Thanks for doing it.
Thank you so much.
Yeah, it's going to be fun. So where are you in the world today?
Where am I in the world? I've been in many places. I've been living in different cities for the past few years. And right now I'm in Miami, Florida. I go to New York all the time for work, for pleasure, but I'm mostly in Miami.
And where are you from originally?
I'm originally from Spain, which is something that people can tell right away every time I start a conversation. But I guess that's good. And I'm originally from Spain. I went to law school and business school in Spain. And 6 years ago, I moved to New York. I went to NYU. I did a master's degree there. And then I also took the New York bar exam. And after that, I got an offer and I moved to one of the top law firms here in Miami. And that's when this all started. And that's when I started working with startups in a great moment, I think, for Miami, because as you know, there's been a lot of changes and a lot of growth in the last few years.
So tell me a little bit more about what you're working on today.
Right now, actually, I just launched my own law firm. The name is Next Legal, and we're a group of partners. All of us like pretty young. All of us coming from big top law firms here in the U.S. But we wanted to create something different for our clients. We wanted to, our law firm, we say it's a boutique law firm, and we are very specialized. So we don't try to cover all areas of law. We try to focus on our clients' main legal needs. So in my case, I focus on venture capital, and particularly on venture capital deals related to Latin America or Spain. And also my partners, they do M&A and real estate. And we try to have give a very personalized service to our clients, and we're really close to our clients, which is one of the things that I like the most. Like I consider many of my clients my friends, and that's basically what we do.
And how did you decide to get into the niche of LatAm venture capital?
To be honest, it's not something I planned. It's something that just happened to me. Like I was very, very lucky to start working with Latin American startups at my previous law firm, and I realized there was a real need for a lawyer that could speak Spanish and English, that was licensed in the US, but also understood the particularities of the region, and that could do like, I don't know how to say, like a bridge between Latin America and the US. Like with my clients, what I feel is there's so many things. They are very busy people. Obviously, they are working on their startup. They are raising funds. They don't have probably enough people in the team right now. So like they really need someone to help them with all the legal needs, to not to make things too complicated, quite the opposite, and especially to kind of translate in all senses what is going on when they are doing a transaction in the US, because it's so different from what they are used to in their home countries, right? So yeah, that's I think my niche, I would say.
And backing out a little bit just from startups and venture capital, can you talk a little bit about the business activity that you've seen running through, say, Florida to LatAm, and why it's been an important part of the business culture in Florida?
Right. Sure. I think there's so many connections between Miami and LATAM. You, as you know, you walk around Miami, everybody speaks Spanish. Business people, like startups, they all have some connection with Latin America, right? And you see, I think a lot of startups from Latin America coming to Miami to meet with potential investors. At some point, they think it's a good idea to come to Miami to try to look for other sources, maybe because they don't find the right sources in their home countries, maybe because they want a different type of investor. So we see that all the time. All my clients usually come to Miami once or twice a year, and they try to meet with the main venture funds here in Miami or angel investors. And I am also seeing the opposite. So like angel investors that live here in Miami, and because they have some kind of connection link with Latin America, because they understand the region, they're also looking for opportunities in Latin America. So all the time I have also clients that are angel investors and funds based here in South Florida, and I help them with investing in Latin American deals. So not I mean Latin American startups with usually a US holding company, but ultimately a Latin American startup because all the operations are in Latin America. So.
And have you seen any changes in the startup ecosystem in Miami or Miami LatAm over the last 4 years or so that you've been involved in the ecosystem?
Yeah, I mean, in Miami, definitely, like you see changes every day, and I think precisely, I mean, one of the changes that I've observed is that there's more and more companies from Latin America. Like here's a great example. This week I was participating as a mentor in 500 startups bootcamp, and most of the companies that were participating were from Latin America, and that's great. Like actually, I was also looking at. I realized about this, and then I read it in also one of your articles about how Y Combinator is finally accepting more and more Latin American startups in their programs. So that's really great news. And
Yeah, no, it's been interesting to see it grow, and especially Miami. I think it always had the LatAm business connection, but up until I would say the last 3 to 5 years, the ecosystem for tech has just really started to take off a lot more.
yeah. Obviously, in Miami, there's still a lot of room for growth and for improvement. This morning, they released an article about Refresh Miami. I don't know if you know this institution. They are doing also a great job here in Miami to develop and improve the ecosystem. So they released an article where they were talking about Miami Angels, which is the largest Miami Angel network, and it was interesting because so they were saying right now there's 115 members in the group. The group has been growing, and that's obviously like really great news. And by the way, like there's this girl Rebecca Danta who is managing the group now, and she's been managing the group for almost for like a year, and she's doing a tremendous work. Like she's so passionate. It's her and Dan who works with her. They are really key to the Miami ecosystem. But anyway, sorry. So the article, what caught my attention is so there's 150 members in the group. The article talks about how this 2018 there was a record in terms of number of deals and investments, and the total investment in 2018 from this group was 3.2 million. 115 members, so that's like what, like $30,000 per member. So, and this is the largest group in Miami. So obviously, I mean, this is really great. And as I said, like this Rebecca, Dan, they are amazing. But obviously, we like hopefully next year we can see more deals, like a larger size of the deals, more success stories in Miami. I think it's going to happen for sure, and it's great to be part of it and see like the trend, right?
So one of the biggest things that's happened in the last, say, 12 to 18 months is that US funds have started to invest a lot more in companies that operate in Latin America. There's been some really big rounds all across LatAm, everything from the Rappi investments, Nubank. You've had Movile get more money in their iFood subsidiary, lots of others all across the region. What kind of legal structures should companies be looking at in if you're operating only in Latin America, but you want to be able to attract US funding?
Right. Yeah, that's definitely true. I mean, we've been seeing exactly what you just mentioned, and so yeah, I mean, from a legal perspective, in terms of corporate structures, it's still the case that U.S. investors don't typically want to invest in Latin American companies. In the sense of what I mean by that is they don't want to invest directly into a company that is organized under the laws of. I don't know, Colombia, Mexico, Peru. They don't know the laws of the country, and if the ticket is substantial, they would ask that the company creates a new holding structure, right? What we've seen in the past, there every VC fund from the U.S. Every accelerator was asking the company to create a corporation, a C corporation in Delaware. That was the most common structure. And with the passing of time, I think U.S. venture capital funds and accelerators, they are getting to know the market. They are understanding better the investments in Latin America, and they have realized that it is not the same to invest in a purely U.S. Company with founders in the U.S., with operations in the U.S., than investing in a company with almost no connections with the US, that which is the case of many of my clients. All the founders are still living in Latin America, and their business model is for Latin America, and they have a huge opportunity, and there's a lot of room for growth in Latin America. There's maybe at some point, yes, they will have some operations in the US, but not necessarily. So that's a completely different type of company, right? And these VCs, these accelerators, they want to still invest in these companies because they see the huge opportunity. And in that case, we've seen that they start to also understand and be more flexible when it comes to the structures, to the corporate structure, and they work with the company to create a corporate structure that is more tax efficient for everybody, and that doesn't necessarily have to be a Delaware corporation. In some cases, that's the most appropriate structure, but it's not always the case. And it's good that they now at least want to contemplate and analyze other structures that could be best for everybody if there is an exit, right?
And what are some of those other places that companies should be looking?
Yeah, so there is, I think that the jurisdiction that is used the most for Latin American investments right now, and it's been the case for a few years now, it's probably the Cayman Islands. And a lot of funds are structured and have the entities incorporated in the Cayman Islands. So the fund itself knows the laws of the Cayman Islands, and actually you can replicate and you can almost have the same rights and terms that you would have in a Delaware corporation in a Cayman Islands holding company. But for a startup that has no operations in the U.S., the Cayman holding company versus the Delaware corporation can be a very good idea and much more efficient. And there's a lot of good resources about this. Like actually, one initiative that I liked very much. Last year I went to Peru, and I was invited to participate. Well, first before my trip, I had been working for some time with Greg Mitchell from Angel Ventures and with Endeavor, and many professionals in both in Peru and in the U.S., accountants, lawyers. Everybody was working on building this brochure or presentation, which was meant to teach Peruvian startups about this precisely, about the like why Delaware corporations may not be the best idea. It explains the pros and cons of each structure, the different factors that they need to consider when deciding which corporate structure is best for them. So this presentation, which obviously it took a few months, a lot of changes, but the good thing is that Greg was and Endeavor were there, like really pushing, and they really wanted to complete it. And I mean, I use it all the time with my Peruvian clients. It's a great resource, and I really think that it would be a great idea to do this in other countries, because the problems are the same. And after we finalized that presentation, what we did is an event in Lima, and they invited all of the Peruvian startups that were in a certain stage. So they had already received seed funding, but they were about to receive to do their Series A round. Their investors were asking for a certain restructuring. They were with so many doubts about whether they should do an LLC or a Cayman or a corporate, sorry, or a corporation. And what they did is they put in the room one of the top law firms in Peru for venture capital, and I went there too to talk about the U.S. legal perspective. And for 1 hour and a half, we were just focusing on that, on like legal matters and corporate structures, and people were asking all the questions, and I think that was a great initiative, and I think that's something that should be replicated in other countries.
Totally agree. There's so many misconceptions and stuff that people get wrong when they're looking at getting started, or just don't even think about it at all. I think one of the misconceptions, and this is more on the accounting side than the legal side, that when a lot of people hear Cayman Islands, they just think, oh, they're just never going to pay any taxes, and they're going to screw their home countries out of income tax, and that's just not right. So can you talk a little bit about why that might not be right? And I know you're not an accountant, but just sort of to get an idea of for people that are just assuming this is, you know what, no startups are going to pay taxes
I
anymore.
get that all the time.
Countries.
Like when I mention this, they are like, oh, and really, and that's not like bad for the company. Are an investors going to be afraid of investing in that jurisdiction? And the truth is, as you said, like it's not about tax fraud, or it's not about, it's really about efficiency. And the company is going to pay taxes on all of its income. It's going to pay, like the operations are going to be in the different countries in Latin America. There's going to be subsidiaries in each country where there has to be one. The subsidiary is going to pay taxes. The only thing, like the main difference, is that a holding company, the holding company, and the purpose of the holding company is just to own the shares of the subsidiaries, right? The holding company usually has no operations, and it just receives the investment, and then it sends the money to each subsidiary to operate. So the whole idea here is just to have a holding company that is as efficient as possible, given that this company is not operating. And obviously, if you have a holding company which is a Delaware corporation, then of course you're going to have to not only file tax returns in each jurisdiction, in each local jurisdiction, but also you're going to have to file tax returns in the U.S. And right now the corporate tax is better. We're at 21%, so it's lower than it used to be, which is great. But still, for a company that has no connections with the U.S., that has no operations in the U.S., maybe it doesn't really make sense to pay taxes in the U.S. and to have double taxation. And particularly if there is an exit, and the exit happens through the sale of the subsidiaries versus selling the shares of the holding company, then there's definitely a big advantage with choosing other corporate structures instead of the Delaware corporation.
So besides corporate structures, what are some of the biggest mistakes or misconceptions that you see LatAm companies doing when they come to you?
Let me think. I would say usually the cap table is not well organized and defined. There's when I start looking at they send me a cap table, and I start asking questions, and I realize that many times what is in the cap table that I receive hasn't really been documented, so it's not real. So that's the first thing. I always have to not only like focus on what I receive and start working like moving forward, but I have to look back and ask all the questions like, was this documented? Send me the documents for this. How did you do this? Like, and make sure that there's documents for everything, and usually it's not the case. So I have to do some cleanup, and sometimes the problem is that if they waited too long, like for example, if they had a commitment from 2 years ago, but it was never documented, things probably changed a lot in those 2 years, and the company's valuation may be higher, and issuing stock at this point we may have to structure things differently, and maybe we cannot meet the exact terms that were promised to this person 2 years ago. So that's important. Like, don't just have like oral agreements or let's like, it's important to have a minimum of I don't know how to say, like seriousness or formality in the documents from the beginning. You don't have to spend like thousands of dollars. It's really not necessary. Most of the agreements that a startup needs at the beginning are pretty standard, pretty simple, and there's good law firms in every country in Latin America that can do those agreements for a very, very reasonable price. So it's important to to do that.
I think one of the things we see a lot on cap tables is sort of either phantom founders who started the business and then left after a short time but weren't subject to vesting, or like advisors that have big chunks of money, not money, big chunks of equity for no money, or very, very little money. It's not really a legal issue, but it's something that we see on cap tables. Do you see that as well? And do you end up having to make changes to the cap tables and restructure when you see companies like that?
So yeah, I mean, that's definitely one of the biggest issues for startups, right? When they are negotiating a Series A round or a Series seed round, and someone asks for the cap table, and they see this person that holds a large number of shares in the company, but is no longer involved with the company. That's really like, that's a big concern for new investors, right? So obviously the best way to address this issue is to do it from the beginning and to have the founders sign repurchase agreements or founders agreements, where if one of them is no longer rendering services to the company can repurchase like most of the shares or all the portion that is invested as of the departure date, right? So that's ideal. The problem is that some companies don't do it from the beginning, and then later on they have to address this issue for the first time, maybe like 2 years after the person left. It's really hard to reach out to the person and mainly to convince the person to sell the stock. So that's one of the main problems, and that can really cause a lot of harm to the company. So like, I think the real advice is like, do it from day one. And regarding the accelerators, angel investors that may have also like a large stake in the company, like with that, obviously there's different institutions. There's accelerators that are really, really great and that really add value to the company. Like, we have many clients, for example, that are participating in Y Combinator in the program, and yes, they had to give, I believe it was like 7% of their company to Y Combinator. But the truth is that going through the program and going to the demo day and presenting in front of all these like investors from Silicon Valley, and like most of them after demo they have like could, if they wanted to, receive investments of like between, I don't know, $5 million and $30 million, which is huge, and have a network that it's only possible because of Y Combinator. So in that case it makes sense. But there's also, sadly, there's also angel investors that try to take advantage of companies when they really, really need the money, and they don't contribute as much, and they still ask for very, very unreasonable terms, and that's something the company has to be very careful with, because it can be a problem later on.
So speaking of unreasonable terms, we review a lot of term sheets for our portfolio, but then also for other entrepreneurs that just reach out and say, hey, I know you're not going to invest in us, but can you take a look at this, just to give us an idea of what terms are okay and which ones are way too strong.
Mhm.
Can you give an overview of some of the terms that you think are overused or unfair to entrepreneurs, or maybe entrepreneurs should at least be on the lookout for, that maybe are not industry standard in the US but get asked for a lot from
Mhm.
LatAm, either VC or angels?
Of course. Yeah, I normally use as a reference whenever I have to comment on a term sheet or a document or a shareholders agreement. Um, the easiest way for me to tell the other party that they are being unreasonable is to show them that it's not because I say it, it's because I say so. It's because they can just look at seriesc.com model documents, National Venture Capital Association model documents, Techstars model documents, and so on and so on. And I tell them, look, none of these documents like have this term that you're asking for. Like, why do you think you need this term? Why do you think? And these are all documents prepared by industry leaders from like that have been developed and improved for many years. So that's always a very good tool in the negotiations. And sorry, I just had an issue with my. I thought I had run out of battery. No. Sorry about that.
No
Um,
worries.
so I think one of the most important things is the terms have to be reasonable compared to the size of the investment. I've seen even like venture capital funds from Latin America be very aggressive. They had only, let's say, 1% of the company, and they were asking for veto rights over every decision and board seats and like things that are really like having that type of shareholders agreement is really going to cause problems for the company. It's not reasonable. And other investors, when they come in and they are making a larger investment and they are going to have a larger stake, and they see this and they say, okay, you gave these rights to this investor and they just have 1%. Why not give the same terms to me, or even better terms, right? So that becomes an issue. It has to be reasonable compared to what the investor is really bringing to the table. So.
Do you have any specifics you can share on terms that you've seen that besides veto rights on, like, what kind of things were they asking for veto on that a no US investor would ask for, or things like we've seen as liquidation preferences that LatAm funds have asked for, or
Mhm.
long term options
Right.
on investing again. Like, can you talk a little bit more about some of those things?
Right. Yeah. I see that a lot. Like when you go to the National Venture Capital Association model documents, when you go to seriesc.com, the list of veto rights, it's usually like 5 or 6 things that the company cannot do without the approval of the investors by majority. So usually things that will have a major impact on the investor stake, like issuing new shares or conducting a deemed liquidation event, like selling the company, or things like that, right? Creating an equity plan, for example, that makes total sense. Like the investor wants to know how big the plan is going to be, what's going to be the dilution. All those things are reasonable. When I do deals with Latin American investors, that list, sorry, tends to be twice the length of the typical US list. So they Latin American investors want to have more veto rights on decisions that relate to the day-to-day business of the company. They try to limit the size of the contracts that the company is signing, like the liabilities of the company. They try to, if there is any change in the business plan, they want to also be able to block it. So things that, I mean, in a startup, things change all the time. Like the company needs to face situations that were completely that are completely unexpected, and the founders didn't think about when they were building their business plan 6 months ago. And sometimes it's hard because it's not that they have to submit these decisions to the investor. Like, I always encourage the company to be super transparent with the investor, to keep them fully informed of anything crucial, anything important happening to the company, even if they are not required to do so by the shareholders agreements. But the problem is that there's like the company has to make decisions, and they have to do that fast. They need to sign those contracts, which is sometimes like a crucial contract for the company, and they cannot wait for a fund to go over like all the internal bureaucracy. Sometimes I mean, it is what it is. It's not the fund's fault, but because of the type of investors behind the fund, sometimes it takes a really long time to get a signature from the VCs. So that can really kill the deal. So that's why the investors have to be reasonable and yeah, have a veto right, but over really crucial decisions, and let the founders run the day-to-day operations.
Yeah, it's super important. And I think that your point about for LatAm investors, if they're asking for something today and they're expecting the company to go well, the terms that they set are what the next investor is going to ask for, if not way stronger. So if you don't have light terms that you can negotiate against, you're now at the mercy of the new investor.
Right.
So unless you're going to be the last investor in, you're basically screwing yourself by putting way too strong of terms.
Yeah.
Just like doesn't make sense.
Exactly.
I think one of the other things that's interesting going back the other way is that is pro rata rights for investors.
Mm-hmm.
So not on the entrepreneur side, but like, for example, in Chile, pro rata rights are in the law. You don't have to put it in the document. So it's just assumed that you have it. Whereas, so some investors, especially angel investors, when they're going to a company that's flipping to the US, they are very surprised that you need to put that in the document, or else you don't have it. Can you talk a little bit about have you seen any situations where that's happened, where LatAm investors have been surprised, and the importance of pro rata rights for, say, investors?
Yeah. I mean, that's one of the rights that everybody wants to have. And sometimes, well, what I tell when I represent the company, what I tell them is, look, this is a right that you're going to have to give to your major investors. Like, the company knows who has the capability, and who really wants to continue supporting the company, and that's good, right? Like, I think the main issue is you cannot, or at least in the US, it's not customary to give pro rata rights to every single investor. Sorry. Also, because in practice it can become really burdensome for the company if they are going to close the new, let's say, a Series A financing round, and they know exactly how much the new investors want to invest and at which valuation. But now they have to look at all of their previous shareholders, and they have to, usually if there's like 4 or 5 the largest investors that have that pro rata right, it's very easy. The company can follow all the shareholders agreements, like notices and all of that. Or sometimes it's easier than that, because they just reach out to them and they say, are you interested in continuing investing in the company? This is the new terms. Do you want to participate? Yes, no. If no, do you mind signing this waiver, so that things can move fast with the new investors? And it's usually quite easy, like with the sophisticated and investors and the accelerators, it's usually very easy. They're like, yes, no. If no, they sign, that's fine. But if you have a cap table with, let's say, I don't know, 50 shareholders, which happens, including friends and family and people that even if they want to, maybe they cannot participate in the next round, but you still have to obtain waivers from all of them, or follow all the notice requirements and everything, then maybe you are adding 2 months to the closing of your round just because of that. So that's why you just have to find out like a reasonable like a middle ground, and offer those pro rata rights to the right people.
So we've talked a lot about what people get wrong. What should someone who's just starting a business, or maybe someone who's started a business in just Latin America, but they're thinking about incorporating outside of LatAm, what should their first steps be, and what are some of the documents they need to be thinking about doing?
You mean when they need to create a holding company in the US, or more like a subsidiary?
So just if say they maybe have operations in one country and they're thinking, I'm going to try to get funding from the US.
Oh, I see.
Or I want to expand to other countries in Latin America. What are kind of like the table stakes documents that that they should be doing, or what are the steps besides obviously going to talk to a lawyer? What should they do?
Yeah, in that case, it's also very important to talk to the local council, because in the end, what you're going to do, if you're going to create, let's say you have to open subsidiaries in multiple countries, and that's why you need a holding company to own the shares of the different subsidiaries, so that your shareholders are all in the same company, and there's only one level, and that's where you have your shareholders agreements, right? That's one of the situations when you need a holding company, or you use a holding company in the US. The other one is because you're going to receive an investment, and the investors are asking that you create a holding company in the US. In either case, it's the same process. So you're going to have to move all of your shareholders from your current company. Let's say we're talking about a Chilean company. So all of your current shareholders in the Chilean SPA have to transfer their shares in the SPA to the new holding company. And in return, they are going to receive shares of the new holding company. It's almost like an exchange or a permuta. But because the transfer is for the shares of the Chilean entity, it has to be analyzed carefully, mainly by the local council, because of the tax implications this transaction can have in Chile, right? And probably most of the shareholders are Chilean residents. So that's usually what we do is. We do that transfer, and then what we do here in the US is we issue the shares or the units to the different shareholders, and of course now we need to replicate what was their shareholders agreement in the Chilean company here in the US. Sometimes instead of replicating the same shareholders agreement, what happens is that there is a new round of financing, so we kind of we skip that step and we go straight to the terms of the new round, and that's more efficient. So what we do is just draft a shareholders agreement at the U.S. company level that reflects all the different rights of the different investors, considering already the terms of the new investment round.
One other thing that came to mind on companies like that where we had an issue is that it's much easier tax wise if you're doing a convertible note or a safe from a Latin American company into the US rather than straight shares if there's been an investment with a priced round, because you could be having the founders having to pay a big tax bill or unwind all of that. That's something that happened to us. So one of the things that I think funds should be looking at more, because I think LatAm prefers priced rounds a lot more than the US does at early stage, that it actually can be a big advantage to have a convertible when you have a company that might want to have a holding company outside.
Right. Yeah, I totally agree.
So going back to your experience, you've been working in the LatAm ecosystem for some time now. If you could go back to when you first started, knowing what you know today, what advice would you give yourself?
I would try to, I guess, ask more questions. Like maybe that was one of my of the things that I didn't do enough. I would just trust whatever like information would come to me from the founders, and as I said before, then I realized that there were a lot of things that had to be cleaned up before moving forward. So now, before jumping into any deal and doing whatever the client is asking me to do, I just for my own like peace of mind, and because I like everything to be very, very well structured and documented, and I don't like to have things that are like not so perfect. So I really like to spend the time of going back to all the documents, taking a look, signing whatever, like side letters with any investor, making sure that everybody is on board with the new transaction, the restructuring. So yeah, having a full picture of everything that is around the company, and try to address that from the beginning.
Do you have any books, blogs, podcasts, documentaries that you like, whether they're related to legal or not, that you'd like to recommend to people?
Yeah, well, there is. I know this is probably like the book that more people mentions, but to me, it was really like the book that I would use at the beginning to prepare when I had to give a presentation, and when I still didn't know so much about venture capital, which is the venture deals by Brad Feld. So, and I've like when every time I talk about this book with founders, I see that they really understand the book. So, which is the most important thing. It was not only helpful for me, but people that are not lawyers really find it really useful, and they recommend it to each other. So I mean, that's it. Yeah, even though it's like the example that everybody uses, I still think it's probably one of the best ones. And also I used to look at the blog that is related to this book all the time too, for looking for examples, because mainly because it was very well explained. So I could use the same example to explain the same issue to my client. So that's what I use in terms of like, or what I found really helpful to understand better venture deals. And the other thing is to always like be updated about, you know, like what is going on in the region. Like there's so many things happening, like new acceleration programs, new funds being created. And for that, I just use your blog and your posts, which is a great source. And so yeah, no, really, congratulations. It's really helpful.
I appreciate it. Where can people find more about you and your business on the internet?
Yeah, so our website is www.nextlegal, so NEXT legal.us, and that's where they can find my information. And yeah, that's
awesome. Well, thanks for taking the time to do this. It was really interesting to go through all of the legal issues and pitfalls that LatAm has when trying to raise money, and mistakes that people make. So hopefully we can avoid some that future founders might have otherwise done.
Mm-hmm. Thank you so much. It was a real pleasure.
Thanks again for listening to this episode of Crossing Borders with my guest Sofia Yagüe of Next Legal. Hope you enjoyed this format where we dig deeper into the weeds of entrepreneurship. If you'd like more episodes like this, or you don't want more, please let me know. Remember, please talk to an attorney or an accountant directly before implementing anything we talk about on this podcast. One last thing before I get going, LatAmlist.com, daily tech news updates about the most interesting tech news happening in Latin America. If you like the podcast, you'll probably like LatAmlist.com. Thanks to Angel and Sofia for helping produce this podcast. If you like it, please share it with a friend and give us a rating on iTunes or wherever you get your podcasts. Thanks again for listening, and have a great rest of your day.